Ready, start. Further, it is also alleged that the petitioner was working as a sales representative in the industrial establishment of respondent number 2, which is a pharmaceutical company, and that, the provisions of sales promotion employees within bracket condition of service bracket close act, 1976 was applicable to the petitioner. Full stop. It is alleged that the services of the petitioner was terminated by an order dated 26th of October, 2002, and the petitioner, being aggrieved, raised a conciliation proceeding under the Industrial Disputes Act. Full stop. It is alleged that there was a failure in the conciliation proceedings, and the Deputy Labour Commissioner, after considering the matter, issued an order dated 13th March, 2003, declining to refer the dispute for adjudication under Section 4-K of the UP Industrial Disputes Act on the ground that it was not expedient to refer the dispute for adjudication. Full stop. The reason for declining to refer the dispute was that the petitioner does not come under the category of the definition of the word double inverted comma workman double inverted comma close as defined under the UP Industrial Disputes Act. Full stop. The petitioner, being aggrieved by the order of the Deputy Labour Commissioner, has filed the present writ petition. Full stop. The learned counsel for the petitioner submitted that the Deputy Labour Commissioner, which is the delegated authority of the state government, has committed a manifest error in declining to refer the dispute, and that the authority had no power or jurisdiction to decide the question as to whether the petitioner was a workman or not under the UP Industrial Disputes Act, and that the power to decide this question only remains with the Labour Court or the Industrial Tribunal. Full stop. The learned counsel submitted that the state government or its delegated authority was vested with the power only to a limited area, namely, as to whether an industrial dispute existed or was apprehended between the parties. Full stop. The question, whether the petitioner was a workman or a sales promotion employee, was not within the domain of the state government to consider or decide this matter. Full stop. On the other hand, the learned counsel for the respondent submitted that the state government was justified in refusing to refer the dispute on the ground that the petitioner was not a workman and that the authority had satisfied itself subjectively on the basis of the material evidence, that was brought before it, to come to a conclusion that it was not expedient to refer the dispute for adjudication. Full stop. The learned counsel submitted that since the petitioner was not a workman under the Industrial Disputes Act, no reference could be made for adjudication under Section 4-K of the UP Industrial Disputes Act. Full stop. In Western India Match Company Limited versus Western India Match Company Workers Union and others, 1970 within bracket 20 FLR, 297, the Supreme Court, following the ratio of the decision in State of Madras versus CP Sarthi, 1953 SCR 834, held that the state government only issues an administrative order while exercising its powers. Full stop. The Supreme Court held that the government could not go into the merits of the dispute. Full stop.